7:20 p.m., the Subcommittee on Criminal Procedure will come to order. The clerk will call the roll.
Chair Pajani,
Here.
Rep Bowers,
Here.
Rep Cook.
Here. The quorum is present. As a reminder, anyone present wishing to testify before the committee, please register at the kiosks located in the hallway behind the hearing rooms. If you require assistance in registering or testifying, please contact the committee staff. Due to the number of witnesses we have registered and to accommodate all those who wish to testify, there will be a time limit of 3 minutes per witness during the public testimony period. The chair lays out HB 1136 and recognizes Chairman Jeton to explain his bill.
Thank you, Mr. Chairman. Members, I'm here to lay out House Bill 1136, which updates the penal code to add compelling prostitution to the list of offenses that registers an individual to the lifetime sex offender registry. This bill will increase the sex offender registry to a lifetime for compelling prostitution. Currently, it is set at 10 years. This is considered a statute cleanup because the disposition of compelling prostitution, first-degree felony, does not match trafficking charge, second-degree felony. With a trafficking charge, perpetrators must register for a lifetime on the sex offender registry. Prosecutors in Fort Bend County want this correction so that they are not constrained by a lesser requirement on the sex offender registry for a first-degree felony. Compelling prostitution is when a person commits an offense that knowingly causes another individual by force, threat, coercion, or fraud to commit prostitution or causes by any means a child younger than the age of 18 to commit prostitution, regardless of whether the actor knows the age of the child at the time of the offense. At this time, I'm able to answer any questions. Otherwise, I reserve the right to close.
Members, do we have any questions for Chairman Jeton? Members, do we have any questions for Chairman Jeton? The chair calls Rhonda Kuykendall.
She's already left.
All right. We'll show her as testifying, or as not testifying, but for the bill. Okay. All right. Is there anyone else who wishes to testify on, for, or against HB 1136? If not, the chair recognizes Chairman Jeton to close on his bill.
Thank you, Chair. Members, this time I close.
Thank you, Chairman Jeton. Is there any objection? The bill will be left pending. I seeing no objection, the chair hears none. HB 1136 is left pending. The chair lays out HB 3686 and recognizes Representative Jolanda Jones to explain her bill.
Good evening. Chair Bojani, and to the respected committee members for your time. I appreciate the opportunity to speak to you about HB 3686, which strives to maintain the integrity of the justice system by not wrongfully attaching arrest records and convictions and files to individuals who are not guilty of the crime they are arrested, charged, or convicted of for possessing or manufacturing drugs when proven laboratory analysis proves that they are innocent. I've taglined this bill, "No drugs found equals expungement." The bill amends the Code of Criminal Procedure Article 55.01A, which relates to expungement exceptions. HB 3686 establishes that a person who has been placed under custodial or non-custodial arrest for committing a felony or misdemeanor is entitled to have all their records and files related to the arrest expunged if two things occur. One, the person is charged solely with an offense involving the manufacture, delivery, or possession of a controlled substance, and a laboratory analysis of the supposed controlled substance actually reveals that no controlled substances were present. And I'll tell you, this came from a number of cases I've had where I represented accused people. And in some instances, after my clients chose to plead guilty because it got them out of jail quicker, even though they always said that they were innocent, right? But the process was taking too long. I actually got a notice sometime this year for a case where I represented somebody in 2019, where it came back, a lab was finally done, was this 4 years later, and it came back no controlled substances. So that client actually has a conviction, and now that client's got to go hire a lawyer and try to get a conviction overturned, which should never happen. But it happens a lot. So this was the most recent one that I got, but it happens all the time. So HB 3686 further goes on to establish that once the charges are dismissed against an individual for the reasons in this bill sets out, then the district or county attorney must enter an order of expunction for the individual. This order must be entered no later than the 30th day after the trial court dismisses a case or once the district or county court receives information regarding the negative lab test. The court may not charge a fee or assess any costs for the expunction. I'll also say I do expunctions, and they are very, very, very expensive, upwards of like $5,000. By the time you've got to, yes, it is. You've got to pay all the law enforcement agencies to wipe their records. You've got to pay for it. I was actually extremely surprised at the cost of it, and most people can't afford that. So why does this matter? Drug charges can have severe and long-lasting consequences, such as a difficulty finding employment, housing, and education opportunities. These charges can also unfairly stigmatize individuals who have not actually been convicted of a drug charge. Restoring individuals with, I guess, for lack of a better word, clean slate after finding they were wrongly arrested, charged, and convicted of a drug case is a crucial step towards reforming the justice system and ensuring fairness for all. So I've talked about them being expensive. It will also save the courts from having to deal with habeas actions or appeals and clogging down administrative procedures, when it'll just conserve and reserve resources that should actually be used for people who actually commit crimes. So I reserve my right to close.
Thank you, Representative Jones. Members, are there any questions of Representative Jones? No. We'll proceed to testimony. Thank you. Chair calls Sarah Mae Jennings. Okay. Chair will make sure that Sarah Mae Jennings is supporting the bill, but not testifying. Okay, thank you. Is there anyone else who wishes to testify on, for, or against HB 3686? If not, the chair recognizes Representative Jones to close on her bill.
In closing, colleagues, HB 3688 promotes accountability and aims to restore trust and rehabilitation. The bill promotes and strives to ensure the integrity of the criminal justice system. No one should be forced to wear a scarlet letter of a crime that has been scientifically proven that they did not commit. Our justice system is not designed to punish the innocent. Therefore, this bill is much needed to create an impactful change. I respectfully ask that you vote in favor of HB 3686, and with that, I close.
Thank you, Representative Jones. Are there any questions of Representative Jones? If there's no objection, the bill will be left pending. Is there objection? The chair hears none. HB 3686 will be left pending. Thank you.
And I have 3688.
The chair lays out HB 3688 and recognizes Representative Jelana Jones to explain her bill.
Good evening again, colleagues. And thank you again, Chairman Bojani, and my respected committee members for your time. I appreciate the opportunity to speak to you about HB 3688, which aims to provide transparency within court documents relating to dismissal of criminal actions against an individual. I've tagged this bill the specific reasons for dismissal bill. This bill amends Code of Criminal Procedure Article 32.02, which relates to the dismissal process by the state's attorney HB 3688 establishes that a state attorney must file a statement of dismissal that includes specific reasons for the dismissal, including lack of evidence of actual innocence related to the charges in this matter. If the specific reason for dismissal is due to the misconduct of law enforcement, then the state attorney is required to do three things. One, include any information related to the misconduct within the dismissal documents. Two, refer the matter to the employing agency of the officer for an internal review. And three, the state attorney must consider if filing criminal charges against the officer is appropriate or refer the case matter to an appropriate attorney who can make this decision. The reason that I filed this bill, I can tell you numerous instances where I've had cases where I found out this to be true, but I'll share one for you. I had a felony case years ago, and myself and another lawyer were doing a motion to suppress, which is why we were trying to have evidence suppressed, because we did not believe that there was probable cause. Only as God or the universe would have it, there were two separate lawyers. Myself, I represented one defendant, and then the other lawyer represented a co-defendant. Well, on the stand, the special detective for a law enforcement agency in Harris County, I'll just leave it like that, was talking about things, was testifying to things under oath that we hadn't read about in the offense report. I mean, and the case had been going on for over a year. So we had deep concerns, myself and my co-counsel, about it. So one of us got up, he got up, I continued to cross-examine the witness and determined after calling a witness, my colleague called another witness who the police officer was actually lying about. And the other witness, well, who's going to be a potential witness, said that stuff isn't true, didn't happen. That witness was in Dallas. We were in Harris County. So when my co-counsel ended up coming out, we asked to approach the judge to say, hey, we've learned that this officer is not telling the truth. We can't get a witness here because he's in Dallas. And so we asked the judge if we could have a continuance in order so that we could properly cross-examine this officer who was on the stand, for the most part, making stuff up. So the judge gave us the continuance for the next week, told us if what they're saying is true, this is very serious and we're going to have to deal with it. So the next week comes, we're set to continue the motion to suppress, and the state dismisses the charges against my client and the co-defendant because they found out that the officer was lying. Well, we couldn't cross-examine the officer because it was moot. If you don't practice law, that means the issue is not there anymore. And at least the way internal affairs works in Harris County is if it's a swearing match between an officer and somebody else, they don't sustain it, right? And so when we tried to file an internal affairs complaint about the officer who lied, the HPD's position was there was not sworn testimony to refute what the officer said on the stand. Therefore, there is not validated. Well, the only reason that there wasn't sworn testimony was because the state dismissed the case and we didn't get the opportunity to cross-examine the officer with the testimony of the person from Dallas. So it goes on and it goes on a lot. That's just one incident. I had other instances where the state literally dismissed the case after their case in chief because I had witnesses who would show that they were lying. And then the dispute is over after that. And there's really no remedy for the person who was lied on or the person who got charged with a crime they shouldn't have gotten charged with, or a person who is afraid and who takes a plea. So that's why this is important, because it does happen. And also with dismissals, and I practice law across the state, right? If in order for there to be an expungement, if you're innocent, the expungement, the dismissal on its face has to say dismissed for innocence. And most times they don't put that. So if they have problems with the case, they'll say see file, which means you've got to go find the file, see what it says, but that doesn't allow you to get an expungement. So I've had prosecutors like, well, your client may have beat the rap, i.e. the case has been dismissed, but your client's not going to beat the ride. and your client's gonna have this dismissal. So when you see them in the future, they're like, oh, the case got thrown out on a technicality, not because the person was innocent. So it's just a way for there to be transparency and to keep law enforcement honest and to not have innocent people be stuck with records and they don't have a way to prove otherwise. So, as I've already said, it's an unfortunate reality of our judicial system that mistakes can happen, and they do happen. In an effort to maintain integrity and restore trust amongst the community, the law enforcement system and court system, I'm seeking to keep mistakes between these entities transparent and specific and documented. And I will also say in dismissals, if they dismiss one case in order to convict you on another, they'll put that on there. So the error is always against the accused person, even though the Constitution says you're innocent until proven guilty beyond a reasonable doubt. So I reserve my right to close.
Sure. Thank you, Representative Jones. Members, do we have any questions for Representative Jones? If not, don't go too far. Is there anyone else who wishes to testify on, for, or against HB 3688? If not, the chair recognizes Representative Jones to close on her bill.
Thank you for hearing my bill. Thank you for no questions. This is about criminal justice reform, about them putting on dismissals, the actual reasons for dismissals, so that people who are not convicted have a fair opportunity to get their records expunged and not have something on their records.
Thank you,
And
Representative
with
Jones.
that, I close and I respectfully request a favorable vote on this bill.
Thank you, Representative Jones.
Thank you.
Yep, members, you have any questions? Representative Bowers.
Thank you, Chairman Bajani, and thank you, Representative Jones. I just want to say, I don't really have a question, but a comment for sure. Thank you for the thorough layout, and that is why we have no questions. So,
I appreciate that.
thank you.
Okay.
Thank you very much. If there's no objection, the bill will be left pending. Is there objection? The chair hears none. HB 3688 will be left pending. Thank you,
Thank you.
Representative Jones. All right. The chair lays out HB 1921 and recognizes Chairman Dutton to explain his bill.
Thank you, Mr. Chairman and members for hearing this bill. House Bill 1921. Essentially what it is a bill that governs Class C misdemeanors, which are generally subject to punishment by fine. In some cases, members, people who receive a Class C fine, they serve out their time in jail. And the day rate now, I believe, is $100, which has been that way for quite some time. And what this simply does is changes that and raises that to $200 a day. So essentially, that's all it does.
Thank you, Chairman Dutton. Members, are any questions of Chairman Dutton? If not, we'll proceed to testimony. Chair calls Sarah Mae Jennings. Let the record reflect that Sarah Mae Jennings is not testifying, but she's for the bill. Right. Is there anyone else who wishes to testify on, for, or against HB 1921? If not, Chair recognizes Chairman Dutton to close on his bill.
Thank you, Mr. Chairman. Members, I will close. This is fairly simple. I think if we had reflected the inflationary changes between the time that this $100 was imposed, it would probably be significantly higher than the $200. But I'm willing to just double it and be done with it. So with that, I leave it to you all.
Thank you, Chairman Dutton. Any questions? No? Okay. All right. Is there no, if there is no objection, the bill will be left pending. Is there objection? The chair hears none, and HB 1921 will be left pending.
Chair recognizes Chairman Bojani with regard to HB 322, which is for Representative Cortez. It's my understanding you're going to be laying out HB 322 on his behalf. Is that correct?
That's correct.
You may proceed.
Thank you, Chairman. And I'm sorry for those members that are waiting. Chairman Cortez had asked me to lay out his bill, and he has a witness that's going to be here, so I just want to make sure. Under the current case law, when a defendant is charged with a crime and found not guilty because of mental insanity, they are often assumed to be mentally insane by default for future cases. HB 322 will remove this prior assumption of insanity for future cases and mandate a certified mental health professional's additional pretrial assessment for the defendant's sanity. This will shift the burden of proof for the defendant's sanity back to the defense, ensuring that any changes in the defendant's mental health are accurately reflected. HB 322 aims to ensure a verdict can be issued without making presumptions about the defendant. Representative Cortez requests favorable consideration on this bill.
Thank you, Chairman Bojani. Ms. Bowers, any questions for Chairman Bojani? All right, we're going to proceed to testimony, and we'll be right back with you. All right, Chair calls Keisha Mitchell Dinkins, is that correct? Okay. We show that you're testifying on your own behalf and that you're testifying in support of HB 322, is that correct? Okay. You may proceed.
I've never done this before.
You'll do just fine.
Quite nervous. On August 17th, 2019, my family and we were playing in the garage. My daughter was on her way to work. We received a call from the hospital that she was in an accident. Shortly before I got that call, I had this intense pain in my stomach, and I didn't want to play with my kids anymore. I didn't know when I answered that phone that call was going to change my life. The officer met us at the door to tell us that we had to go to the hospital right away. When we got to the hospital, we were in a dark room and alone. When I finally was able to see my daughter, she was in ICU and she suffered a serious brain injury. Shortly after that, they told me that they needed to check the brain activity, and her brain activity, there was none. On this day, my daughter was on her way to work. Mr. Gregory Sue was taking another individual in a car somewhere, I'm not really sure where. My daughter was getting ready to get on the highway. There was an intersection. She was parked in front because of the construction that was going on. He was angry with the individual in the car and he put his foot on the gas. He T-boned my daughter. The car flipped numerous times, claiming her life. The individual in the car with him, she suffered a serious brain injury as well, and she has a memory problem right now. She does not know where she is. With this Texas 46C law, I would like to make some changes. So because he was previously found not guilty by the reason of insanity, he receives a benefit the second time around. The law gives him the benefit that he is presumed to once again not know that his actions were wrong at the time he plowed his vehicle into my daughter's vehicle, claiming her life. I'm asking that you take away the presumption benefit. This man was under court order treatment, and yet he gets the benefit that society still does not think he knows the difference between right and wrong. Something is wrong with that. I'm asking the state to hold individuals accountable for their actions. Do not continue to give individuals the benefit of making the state or the victims prove that the criminal understands what they did was wrong. We should soon, they know
Is there one more witness?
the difference between right and wrong already. Please stop this benefit given to the criminal. I feel like the state, the system failed my daughter. There is no justice. He was granted this plea, and I will continue to fight for her. I will be her voice. I do not want any other families to have to go through the things that I am going through. Please, if we can make this change. Thank you.
Thank you for your testimony and apologize for your loss. Thank you for being here. Next, the chair calls Ms. Lisa David. Is it David or Davis? It is David. It is David. D-A-V-I-D. Okay. Not here. And she in favor.
I'm Lisa David, and I'm here for 4671.
4671. Okay. So do we have your permission to change our records to to withdraw you from 322?
Yes, sir.
And you want to testify on 4671 instead?
Yes, sir.
You need to get her to, you need her to, like to go.
Don't necessarily want to bring up another bill.
Right, but you want her to,
Only have one bill in front of us.
right, but do you want to go, her to go outside?
Oh, yeah, I'll take care of that.
Okay. All right, is there anyone else that wants to testify on behalf of House Bill 322? Chair here,
I'm sorry, I didn't sign up at the kiosk. Do I need to
Oh,
do
yeah,
that?
yeah, I can.
if you'll come on up here and she'll get you registered. Yeah, right over.
Sorry.
That's all right. Yes. All right, Chair recognizes Karen Marshall, and are you testifying in favor of the bill?
Yes, sir.
Okay, and you're representing only yourself and?
Correct, sir.
Okay, you may proceed.
And I apologize for the delay.
No worries.
All day I've heard Keisha's story, and it's incredible. It happened in my town in San Antonio, and I found out that the man who had hit her daughter had previously shot his wife and had been found innocent by reason of insanity. A couple of years later, he was found competent to be released from the state hospital, and 2 months after that, this accident. So he was automatically, somehow by the law, provided the advantage of a innocent by reason of insanity. And so the second time around, and from then on, the person is automatically granted that benefit of being, of the insanity plea, and it is up to the prosecutors or the victims to prove otherwise, rather than the reverse, which was the first time. And so what this law requests is that it be turned back so that they must be reevaluated each time and proven that they were insane. The trouble is, it's very difficult to prove that they weren't, which is the burden then on the prosecutor or the victim, because, like, for example, in this case, there was no cameras in the car. The only witness inside the car has been seriously brain damaged. And this man, in theory, it could happen all over again. He'll be in the hospital for a few years. He will be deemed competent, and then he will be let out again, and it could repeat. The trouble is that he also somehow was competent enough to enter a plea, and one must be competent to enter a plea. And yet, he's automatically, by law, allowed to enter and presumably insane at that moment. And so just to save the next person who would come up and encounter this man, please support this bill. Thank you very much.
Thank you for your testimony. Is there anyone else who would like to testify on, for, or against House Bill 322? Hearing none, Chair recognizes Chairman Bojani to close on House Bill 322.
Thank you, Chairman. Representative Cortez requests favorable consideration on his bill, and I close.
All right, thank you. Go ahead. Did you have another bill? That's it, okay. Yeah, if there's no objection, we'll leave House Bill 322 left pending. Is there any objection? Chair hears none. It is so ordered.
Chair lays out HB 1230 and recognizes Representative Jessica Gonzalez to explain her bill. And the chair offers a committee substitute for HB 1230.
Thank you, members. Thank you for the opportunity to present this bill to the subcommittee today. Currently, there is no statewide witness protection unit available to Texas residents who are witnesses in criminal cases and are later at risk for retaliation because of their participation in a trial. The committee substitute for HB 1230 is a result of conversations between myself and Senator West on how best to protect witnesses in Texas. The substitute brings 1230 in line with the substitute language of SB 839. The committee sub for 1230 would establish the Witness Protection Unit in the Department of Public Safety and be under the administration of the director. The Witness Protection Unit would be made available to witnesses and witnesses' families if needed at the request of the prosecuting attorney. Additionally, it establishes training for prosecuting attorneys to learn witness protection procedures and best practices, the types of cases for which the unit may protect a witness, and the processes the unit will use to approve a request for witness protection. 1230 follows the lead of over a dozen states to ensure that individuals have access to adequate protection after acting as a witness for a criminal case. If there are no questions for me, I reserve my right to close.
Thank you, Representative Gonzalez. We'll proceed to testimony. The chair calls Andrew Novak. Thank you for being here today. We show you registered as Andrew Novak on behalf of yourself and the Dallas County Criminal District Attorney testifying for the bill. Is that right?
Yes. Yes, thank you, Chairman Bojani, Vice Chair Cook, esteemed members of the committee. My name is Andrew Novak. I'm a chief prosecutor at the Dallas County District Attorney's Office. I'm deputy chief of the Organized Crime Division, representing Dallas County District Attorney John Creuzot. This bill will create a powerful resource for prosecutors dealing with key witnesses refusing or feeling unable to testify because they are afraid of the defendant or associates of the defendant. This program will be an accessible and effective safety net to offer in murders, aggravated assaults, aggravated robberies, violent gang crimes, or other cases where key witnesses and sometimes their families are endangered due to the ongoing investigation or anticipated testimony. In one of my recent cases, a key witness in a murder trial was physically assaulted prior to testimony by members of the gang of which the defendant was a member and was shot at by members of that same gang after his testimony. In another case, I had a single mother and school teacher who was willing to stand up to the criminal element, a key murder witness, yet she suffered gang members driving past her house repeatedly prior to trial, threatening her life. These are the people who will benefit from HB 1230. The protection of witnesses is essential to attaining convictions and maintaining public confidence in the effectiveness of government in protecting our citizens and for the preservation of the public peace, health, and safety. This bill will exponentially increase safety in our criminal justice system and send an impactful message to violent criminals that witness intimidation and retaliation will not be tolerated in Texas. Most importantly, this bill lets witnesses know in a truly tangible way that they are valued and that their safety and protection are a top priority. And I can answer any questions.
Thank you, Mr. Novak. Representative Gonzalez did a good job by getting somebody from North Texas. You have any other? Okay, right. Is there any other witness who wishes to testify on, for, or against HB 1230? If not, Chair recognizes Representative Jessica Gonzalez to close on her bill.
I close.
Thank you, Representative. The committee substitute to HB 1230 is withdrawn, and if there are no objections, the bill will be left pending. Is there any objection? The Chair hears none. HB 1230 is left pending. The Chair lays out HB 1232 and recognizes Representative Jessica Gonzalez to explain her bill.
Thank you for the opportunity to lay out this bill as well. Currently, our Code of Criminal Procedure outlines the permissible installation and usage of certain tracking equipment by what we call a designated law enforcement office or agency. Currently, the entities that qualify for this designation are a sheriff's department of a county with the population of 3.3 million or more, a police department in a municipality with a population of 200,000 or more, and the Office of the Inspector General of the Texas Department of Criminal Justice. However, it has been brought to our attention that it would be helpful for a large district attorney's office to be included in this designation. HB 1232 is a simple bill that adds large prosecutors' office, those that are in a county with a population of 2.1 million, to the list of these designated law enforcement office or agency. This would allow prosecutors to possess, install, operate, or monitor PIN registers, ESN registers, which are electronic serial number readers, or similar equipment. Additionally, it would require prosecutors to submit a written report of tracking equipment expenditures to the director of TDCJ. Lastly, it would permit prosecutors of law enforcement offices to issue administrative subpoenas to communication carriers or providers of electric communication services. This bill makes a small change to the Code of Criminal Procedure to permit district attorneys' offices in large counties to use PIN registers, ESN readers, or similar equipment. This bill would streamline the usage and application of certain tracking equipment by including the prosecutor's office as a designated law enforcement officer agency. If there are no questions for me, I reserve my right to close.
Thank you, Representative Gonzalez. Chair calls Paige Williams. Thank you for being here today. We show you registered as Paige Williams on behalf of Dallas Criminal District Attorney, and you're for the bill. Is that
That's correct.
Okay, thank you.
I just want to point out that this simply adds Dallas and Tarrant counties. So it's only this bill only affects the Dallas County and Tarrant County DA, adding them to the designated agencies for the purposes of 18B. This is a bill of convenience. Harris County can already do this. Our counties in the Metroplex are very unique because we have one or two large cities and multiple small cities. The small cities cannot access this information unless they go through DPS or have a memorandum of understanding with the larger agencies such as Fort Worth Police Department or the Dallas Police Department. By allowing the DA's offices in these two counties to be part of the designated agencies, you are giving the smaller agencies another avenue in which they can shrink the time that they seek the warrants that they need for investigations. Because If they go through our office, the judges are right down the hall. Again, this is a bill of convenience. If you've ever driven in the Metroplex between 6 a.m. and 9 p.m., you know it is difficult to get from one side of the county to the other. In Tarrant County, Fort Worth, and Arlington are the only two agencies that can currently ask for these warrants. There are 40 cities inside Tarrant County that cannot and have to go through another agency. In Dallas, we only have Dallas, Irving, and Garland, and we have 28 cities that fall under the categories of those not eligible to go through, that will have to go through another agency to obtain these warrants. This, again, is for convenience. We are simply trying to streamline the system and give our smaller agencies the ability to do what they do best, investigate crime.
Thank you, Ms. Williams, for
Thank
being here. Appreciate it. Is there anyone else who wishes to testify on, for, or against HB 1232? Okay. If not, the chair recognizes Representative Gonzalez to close on her bill.
Thank you. I close.
Thank you, Representative Gonzalez. Is there any, if there's no objection, the bill will be left pending. Is there objection? The chair hears none. HB 1232 is left pending. The chair lays out HB 5041 and recognizes Representative Garcia to explain her bill.
Thank you so much, Chairman Bajani.
Thank you for being here.
House Bill 504 would ensure local courts are able to operate efficiently by allowing any competent lawyer to be appointed to replace an attorney for the state. This bill would help address worker shortages. Excuse me real quick, my page flipped. When an attorney for the state must recuse themselves or is unable to perform their duties of their office, the Code of Criminal Procedure requires that an attorney be appointed to stand in their place. Before the 86th legislative session, any competent attorney could be chosen to replace a state prosecutor in these instances. However, after passage of Senate Bill 341 in that session, the field of potential attorneys was significantly narrowed to only an assistant attorney general or another attorney for the state. Since 2019, our court systems have undergone serious and ongoing challenges as a result of the pandemic. Court closures, social distancing requirements, and staffing shortages have contributed to a large backlog of criminal proceedings, which reached 140,000 cases in the summer of 2021. The backlog has affected communities across the state and could still take years to fully resolve. Criminal caseloads continue to grow in my county of Bexar, and the narrow field of professionals who can be appointed as attorney pro tem under current statute is a barrier to our judicial system functioning efficiently, resulting in delayed justice for both victims and defendants. The challenges are especially burdensome on counties with a district attorney who was previously served as a defense attorney, since they are more likely to have to recuse themselves from criminal cases being prosecuted in their offices. As a result, the attorney pro tem requirements currently in statute disadvantage Bexar County, Dallas County, Travis County, Nueces County, and many other communities across the state. House Bill 5041 would meet these challenges by once again allowing any competent attorney to be appointed to replace an attorney for the state. This bill would also allow for this new class of appointed attorneys to receive compensation for their work equivalent as if they were representing an indigent defendant. If there are no questions, I reserve my right to close.
Thank you, Representative Garcia. Don't go too far. Is there anyone else who wishes to testify on, for, or against HB 5041? If not, the chair recognizes Representative Garcia to close on her bill.
Thank you, sir. Thank you, Chairman Moljani. House Bill 5041 would ensure local courts are able to operate efficiently by allowing any competent lawyer to be appointed to replace an attorney for the state. This bill would help address worker shortages and criminal case backlogs in communities across the state. If there are no further questions, I close and request a favorable referral of House Bill 5041.
Thank you so much, Representative Garcia. You did a great job. Thank you. If there's no objection, the bill will be left pending. Is there objection? The chair hears none. HB 5041 is left pending. The chair lays out HB 2380 and recognizes Vice Chair Vasu to explain his bill.
Thank you, Mr. Chairman. And did you just say point of order? Lulu's mad at me from earlier. For the opportunity to lay out House Bill 2380 in 2021 last session. We passed HB 569, good bill. Increase the credit a defendant receives towards fines from $100 to $150 for each day the defendant remains in jail. Unfortunately, one unintended consequence of that bill, as worded, was to effectively incentivize defendants to remain in jail, receiving $150 per day instead of pursuing community service options, which only are accredited at $100 per day. House Bill 2380, simple cleanup bill. It increases the credit for community service towards fines from $100 to $150 so that they are even, and also extends the credit to time spent in jail awaiting trial. Happy to answer any questions. Respectfully reserve the right to close.
Thank you, Vice Chair Vasu. We're going to proceed to testimony.
Thank you.
Chair calls Sarah Mae Jennings. Thank you for being here today. We show you registered as Sarah Mae Jennings on behalf of Texas Fair Defense Project for the bill.
And on behalf of myself.
On behalf of yourself, yes.
Yes.
Thank you.
Thank you. My name's Sarah Mae Jennings. I'm the interim co-executive director at the Texas Fair Defense Project. We're a nonprofit organization that fights the criminalization of poverty in Texas, and I'm here today to express our very strong support of House Bill 2380, which is a simple cleanup bill to fully realize what the Bond and Farms Act set out to do last session. At TFDP, we represent hundreds of Texans each year who cannot afford to pay their criminal legal debt. We mostly represent people on fine-only Class C misdemeanor cases and related legal debts where there is no right to counsel if you cannot afford a private attorney. Although we help as many individuals as we can, there will always be more Texans in need of assistance than we and the other pro bono resources in the state are able to assist, which is why legislation like this bill is so important. Last session, the legislature unanimously passed House Bill 569 into law. That bill raised the jail credit rate for Class C misdemeanors from $100 per night in jail to $150 per night in jail. However, normally this amount has always been raised in concert with jail credit rates for other offenses, as well as in concert with the community service rate, and those rates remained unaffected. Stakeholder judge associations at the time agreed that the rate should be raised across the board and that we should come back the next session to do so. This bill does just that. This bill will do three things. First, it'll standardize the jail credit rate for all levels of offenses to $150 per day. Second, it'll raise the community service rate in concert with the jail credit rate from $100 to $150 per day, which is 8 hours. And third, it'll expressly provide for pretrial detention jail credit. I taught a course through the Texas Justice Courts Training Center's core curriculum entitled Clearing Your Docket While Helping Your Community. Justice of the Peace Court judges across the state are eager to utilize community service credit and jail credit to close out old cases on their dockets. And this bill empowers them to continue to do even more of this important docket clearing work. This bill would also clear up confusion around jail credit in Class C cases. Because of the way the Class C jail credit provision is currently worded, it technically only mandates credit for a conviction. Thus, people who are detained pretrial whose cases are ultimately dismissed are not receiving the same benefit as people who are convicted. House Bill 2380 will ensure that individuals who have served any time in jail will receive this credit. This bill will help judges across the state clear their dockets while helping their communities and would be an important step for equity in Texas. Thank you for your favorable consideration of this important piece of legislation. I welcome any questions.
Thank you, Ms. Jennings. Members, do you have any questions? Thank you, Ms. Jennings.
Thank
Appreciate
you.
it. Is there anyone else who wishes to testify on, for, or against HB 2380? If not, Chair recognizes Vice Chair Vasood to close on his bill.
Thank you, Mr. Chairman. I close.
Thank you, Vice Chair Vasood. Any questions, members? All right.
Very much.
Thank you. If there's no objection, the bill will be left pending. Is there objection? The chair hears none. HB 2380 will be left pending, is left pending. Thank you. The chair lays out HB 1178 and recognizes Vice Chair Rogers to explain his bill.
Thank you, Chairman Bajani and Representative Bowers. Thank you for the opportunity to lay out House Bill 1178. HB 1178 is a bill that would expand the powers for issuing a search warrant to collect a blood specimen. This would include criminal offenses such as driving while intoxicated. Any magistrate, including those who are not attorneys, would be eligible to issue these warrants. Enhancing the ability to obtain blood alcohol concentrations and to more efficiently prosecute DWI cases is very important for the safety of Texans throughout our state. Post-trial, jurors have often stated that the availability of a breath or blood test is the most important piece of evidence used to make their decision. Breath test refusal rates are extremely high, especially with repeat offenders. An alcohol concentration result can change a case from a tough case on which to obtain a conviction to a solid case likely to result in conviction. Even though nationwide fatal crashes resulting from impaired driving have been reduced over the last 3 decades, there's still room for improvement. According to Mothers Against Drunk Driving, a person drives drunk an average of 80 times before they're arrested. TxDOT reports there were 19,000 crashes involving drug and alcohol impaired drivers in 2021, and these crashes resulted in over 1,000 fatalities. With this bill, we can make Texas roads safer by allowing any magistrate to issue a search warrant and take more drunk drivers off the roads. Thank you for your time, and I respectfully request the right to close.
Thank you, Vice Chair Rogers. Members, any questions of Vice Chair Rogers? No? All right. Thank you. Proceed to testimony. Thank you. Okay. The chair calls J.R. Woolley. Did I say that right? Thank you for being here today. We show you as registered as J.R. Woolley on behalf of Justice of the Peace and Constable Association of Texas and yourself, and testifying for the bill.
That is correct. Thank you, Chairman.
Thank you.
Good evening. I think one of the most important things that Dr. Rogers laid out there was one of the last things he said, and that's that this bill makes Texas safer. And it absolutely does that. We've worked with him some on this bill to make it the best bill it can be. One thing I'd like to put into here too is that we as the magistrates, justice of peace that are not attorneys, can find probable cause for the arrest for these DWI offenses. Well, the probable cause to draw the blood is identical, but we're barred from signing that warrant to allow that blood to get drawn so that that person can be prosecuted. This makes law enforcement has more options to get those warrants signed to draw the blood, to allow for prosecution of repeat offenders of DWI, which obviously makes Texas safer. And I think that's the biggest part of this bill, is that it makes for a safer Texas.
Thank you, Judge Woolley. Members, do we have any questions for Judge Woolley? No? All right. Thank you for your time. The chair calls David Gonzalez. Okay, we'll show that David Gonzalez is not testifying, but he's for, or he's against. Okay, do not testify. Okay. The chair calls Stephen Brand. Thank you for being here today. We show you as registered as Stephen Brand, testifying on your behalf and TCDLA against the bill.
That is correct. That's against the bill. I know David's sorry he couldn't be here. Personal thing to attend to. Yeah, I appreciate the opportunity to speak.
I'm sorry.
Yeah.
Is somebody? Stephen, are you sure you're Stephen Brand?
Yeah, I've.
Okay, all right. Just wanted to make sure. Okay.
Should I show it?
Oh, no, it's okay. I just want to clarify. Sorry about that. Go ahead, please.
Okay.
Continue. Thank you.
Yeah, I'm speaking on behalf, in part of Texas Criminal Defense Lawyers Association. The intrusion of the government actually sticking a needle in somebody. I don't like needles. I don't know that many people that do like needles. But you're sticking a needle in somebody based on probable cause to believe that they were driving while intoxicated. And what this bill wants to do is interject non-lawyers into that process. There's 3 years worth of training that we go through, which costs a lot of money, by the way. But, you know, I don't want to undermine that training. There's case law we review and keep up with. Not saying that non-attorneys can't or don't, but there's specific training that we go through to analyze that. There are alternatives rather than opening this up to non-attorneys, because the irony of this is who, once the blood draw is authorized, is actually taking the blood? Licensed people. I don't see anybody asking to open that up, saying, well, you know what, just the average person can take a blood draw and just actually stick the needle in somebody. No, the transportation code says it has to be a nurse or a qualified technician, people who are specifically trained in these areas. You have magistrates who are licensed and took the bar for a reason. And those should be the people continuing to make these decisions. In terms of not getting them, nowadays, especially post-COVID, people would have the ability to go online via Zoom, electronically, whatever it may be, to get access to an attorney magistrate to be able to do that. So I don't see this in terms of, oh, well, just because in some ways it's more convenient in some smaller counties to be able to do this doesn't make sense to me when the technology is there to do it another way, especially when you're talking about a bodily intrusion into somebody, sticking physically a needle into somebody. That needs to remain with the decision of a licensed attorney who also, under the circumstances, is a magistrate.
Thank you, Mr. Brand. Members, do we have any questions? Okay. Thank you very much for your testimony. Chair calls Jeff Swain. Did I get that right? You did. Okay. Thank you for being here. We show you as Jeff Swain testifying on behalf of Parker County District Attorney, Parker County District Attorney's Office, and testifying for HB 1178. That's right.
Yes, sir, that's
Okay.
correct.
Thank you.
All right, thank you, Mr. Chairman, members of the committee. Appreciate the opportunity to address y'all today. My name is Jeff Swain. I'm the District Attorney of Parker County, and I'm testifying in support of House Bill 1778. I want to start, I've been a prosecutor for 27 years, just over 2 years as the elected DA. I have prosecuted thousands of DWI cases. I've tried dozens, prosecuted hundreds of felony drunk drivers, many intoxication, assault, manslaughter cases. These are very serious cases, but inevitably at the end of the trial, the most important thing we hear from the jurors is what the blood alcohol concentration was, or if we didn't have that, why didn't they have that evidence? That's very crucial evidence to our jurors. They want it. And frankly, we've been bringing it to them for quite some time. This bill is not anything new as far as a procedure goes. We've been doing these DWI blood alcohol warrants for years, and we do them in our county. This is not a new thing. What it does is it expands the workload to include other judges so that in our county we have a rotation or schedule. At this point, we have 5 judges who can sign these warrants in our county. 2 district, 2 county court of law, and 1 attorney who is a justice of the peace. This would allow us in our county to expand that to 10. So when each judge is on rotation for a month at a time, they're basically on every other month. This would have them be on for basically twice a year. So the judges will have a lot more of an opportunity to rest and schedule their lives as well. I want to point out that we already do, and I actually didn't intend on bringing this up, but we already do in response to the gentleman that just spoke before me, we already have non-lawyer JPs who are able to issue these exact same search warrants in some of our smaller counties. The real hole that we're trying to fill with this bill, the large counties have plenty of attorney magistrates. The small counties have the ability to have their JPs and non-attorney magistrates sign them already. It helps for the middle-sized counties. Non-lawyer JPs have all the expertise they need to consider these warrants. They can magistrate them in the morning, find the probable cause to make the arrest that evening. They might as well be able to sign the warrants in the middle of the night. It's the exact same probable cause determination. These judges already signed probable cause arrest warrants for capital murder, engaging in organized criminal activity, aggravated sexual assault of a child. They signed search warrants for contraband, for stolen property, very complicated matters. These are not that complicated. And just in closing, just because you probably don't have a lot of experience, most people don't, with search warrants, I brought some search warrants. If I may, I'd like to give those to y'all. I brought 6 copies. I have more.
Thank you. No, that's plenty.
I have
Thank
a
you.
dozen, but seeing there's 3 of y'all, I didn't want to do overkill.
Thank you.
These are really fairly simple warrants. The first 2 are DWI blood search warrants. The last one is just an injury to a child case. And these DWI blood search warrants are very repeated formats. Officer finds, driver sees them driving, pulls them over. Somehow they failed field sobriety tests, they're arrested, they go to jail. Fundamentally, that's all there is to them. It's the same fact pattern over and over again. They're a simple search warrant. So with that, I will conclude, and I would urge your support for House Bill 1178, and I'd be happy to answer any questions y'all may have.
Thank you, Mrs. Swain. Members, do you have any questions? No. Thank you
Thank
so
you
much
very
for your
much.
testimony. Is there anyone else who wishes to testify on, for, or against HB 1178? If not, the chair recognizes Vice Chair Rogers to close on his bill.
Mr. Chairman and members, this is not about increasing the workload for non-attorneys or reducing attorneys' responsibilities. What this bill is about, as has been mentioned, is about improving the safety of Texans by removing more impaired drivers from our roadways. Thank you for your time, and I ask for your favorable consideration.
Thank you, Vice Chair Rogers. Members have any questions? No. Thank you so much for your time. If there's no objection, the bill will be left pending. Is there objection? The chair hears none. HB 1178 is left pending. The chair lays out HB 1017 and recognizes Representative Sherman to explain his bill.
Hello, Vice Chair Bajani. Thank you, and fine members of this committee. Thank you for the opportunity to lay out HB 1017. HB 1017 seeks to expand the protections for victims of family violence by updating current language in the family violence provision of the Criminal Code to include language in the Family Violence Provision Criminal Code to include offenses that are present in family violence cases but are not included in the family violence provision. This bill's implementation will change a victim's classification from victim to family violence victims, which opens the door for access to more services such as safe houses or counseling that are designed to help victims of family violence. Currently, a judge has the authority to make an affirmative finding of family violence in a trial of offenses. Many family violence cases are excluded from this list because they do not appear under Title V of the Criminal Code. This bill intends to identify specific offenses for which a judge is authorized to make an affirmative finding of family violence, in addition to assaultive offenses listed in Title V. This bill would expressly include injury to a child or elderly individual, stalking, and violations of protective orders, since these are offenses that epitomize power and control in family violence cases. Thank you again, Chairman Pachani. our Vice Chair Bajani and members, or a member of this committee, and I reserve my right to close.
Thank you, Representative Sherman. Are there any questions?
He is the chairman.
Chair.
He is the chairman.
Chair.
I'm honored to be.
I don't know what I was thinking.
It's okay.
Chairman,
Don't worry.
thank you, Retta Bowers.
Thank you.
Vice Chair.
Thank you. We'll proceed to testimony. Thank you.
All right, thank you.
Chair calls Paige Williams. Thank you for being back. Thank you for being here. We show you as registered as Paige Williams on behalf of Dallas County Criminal District Attorney's Office, testifying for HB 1017. Is that correct?
That's correct, Chairman. Domestic abuse, family violence, and intimate partner violence can have many forms. We know about physical, sexual assault, threats, intimidation, financial control, removing you from your loved ones, all of those actions that make up the age-old cycle of violence. But what we are currently seeing right now in family violence is situations in which we cannot ask for an affirmative finding of family violence because it falls outside of Title V. We are seeing perpetrators with more frequency using offenses outside of Title V to exert the control over their victims. Recently in Dallas, we had a defendant who was tried for breaking into an ex's residence, strangling her, and running off. Through the hard work of the prosecutor and the willingness of the survivor to testify, he was convicted of burglary with the intent to commit assault. But since burglary falls under Title VII, the prosecutor could not ask the judge to find an affirmative finding of family violence. The prosecutor, in order to get the affirmative finding, the prosecutor would have had to try the individual for a lesser offense in Title V. Without the affirmative finding of family violence, we leave our perpetrators in situations where they are eligible for things an individual that has an affirmative finding is not typically eligible for. We leave our victims in a lurch. There are certain things that become available to them with the title of affirmative finding of family violence survivor, such as being able to get out of their lease if they need to remove themselves from the situation. That's a big one. Changing this law doesn't allow anything more than what we can already do. I want to make it very clear, we cannot take guns away with an affirmative finding. We cannot enhance your case with an affirmative finding. What we can do is we can use it in punishment if you commit another offense. And we can start identifying those individuals that may need to go through some help of their own. The current state of the law limits a judge from making a reasonable determination that a crime was based on family violence as it stands right now. This bill would open it up to every offense in the penal code if the state proves the elements necessary to have family violence. The fact that you can burn down an ex's home or rob your parents at gunpoint and the crime is not deemed family violence is an egregious gap in the law, and it must be fixed. That is exactly what House Bill 1017 does, and we request that you vote favorably on it.
Thank you. Thank you, Ms. Williams. Members, any questions? No?
Thank
Okay.
you.
Thank you for your time. Is there anyone else who wishes to testify on, for, or against HB 1017? If not, Chair recognizes Representative Sherman to close on his bill.
Thank you, Chairman Bajani. Thank you, committee. With that, I think you understand the importance and the weight of this legislation, and I request your favor in considering this legislation. With that, I move to close, sir.
Thank you, Representative Sherman. Any questions, members? No. Thank you so much for your time. If there's no objection, the bill will be left pending. Is there objection? The chair hears none, and HB 1017 is left pending. Chair lays out HB 3005 and recognizes Representative Flores to explain her bill. Thank you for waiting. Appreciate it.
Hi, thank you. Good evening. Thank you, Chairman Bojani and Representative Bowers. This is a simple bill that will provide more protections to victims of certain assault cases. It's been brought to my attention that victims of visual recordings and indecent assault are not allowed a pseudonym when pursuing their case. These crimes cause severe mental trauma to victims as is, and having to publicly be out while seeking justice often deters many from seeking justice. The reason for this bill is due to a case that was here in Travis County where a woman learned that she was being recorded while nursing at her place of employment and was left in a difficult position of being exposed at work. As with many of these types of cases, victims are often embarrassed or shamed, and they shouldn't be. This bill will ensure an extra level of protection and bring more people to justice. This bill is not an enhancement bill, as it doesn't change any of the punishment or requirements to prosecute these cases. It simply is expanding the types of cases where a victim can seek a pseudonym. If there are not any questions for me, I reserve the right to close, but I do believe there's someone here who may be able to answer any technical questions you may have, and I believe there's lots of people that signed up but do not wish to testify.
Thank you, Representative Flores. Members, any questions for Representative Flores? Thank you so much. We'll proceed to testimony. Chair calls Stephanie Karakanian. Did I get that right? You did. Okay, thank you. Thank you for being here. We show here that you're testifying as Stephanie Karakanian on behalf of Assistant District Attorney, Travis County District Attorney's Office, and yourself, and you're testifying for HB 3005.
That's correct.
Okay, thank you.
Good evening. As Representative Flores mentioned, this is a bill that's inspired by a case that came through the Travis County District Attorney's Office involving a woman who was expressing breast milk at work. She was pumping, and then later learned that she was being filmed without her consent by a coworker at her place of work. When she agreed to participate in the investigation and prosecution of her case, she did request a pseudonym. Everyone around her started the paperwork assuming that this was an offense that was covered because so many other sexual offenses are currently covered by the pseudonym statute, and we're really astonished to learn that actually she did not qualify. Later conversations that we had internally at our office with the victim witness counselors that we worked with also revealed that indecent assault is another offense in which victims commonly have been requesting a pseudonym. Indecent assault is a more recent provision in our penal code. And in those instances as well, we've learned that victims do not qualify for a pseudonym, which is surprising to many because indecent assault is very similar to the lesser offense of indecent exposure, which is currently covered in the pseudonym statute. So as a district attorney's office, we support this bill because we believe that access to pseudonyms are really important as a tool to promote public safety. We know that they will increase the likelihood that a victim will cooperate with our office, cooperate with law enforcement. And we also recognize that pseudonyms in these cases are very important to the victims themselves. Access to a pseudonym can help a victim feel safe moving forward. And in many instances, victims view access to a pseudonym as very important in their own journey of healing. Many victims do not want to be associated forever in the public record with a defendant who was responsible for one of the most traumatic or harrowing moments of their life. So just to close, I wanted to actually share some words from the victim who inspired this case in our office. She wanted to be here but was unable to be here, and she shared the following. She said, "I worked with the defendant for some years, but now because of the current laws in Texas, my name will be permanently tied to his in his legal documents. I wanted to press charges and did for the crime of invasive visual recording. That particular crime is not on the list of crimes that allow victims to use pseudonyms. If I wanted to press charges, I had to use my real name. If I wouldn't use my real name, there would be no case to file." Using my real name would mean that anyone with access to legal cases would be able to search and find me by my name, despite me being the victim of a sex crime. This makes me very disappointed in the system. I was a victim, and now I'll be in searchable court records in perpetuity, tied to a gross crime committed by a depraved coworker. She went on to say, even though I was so angered by the crime against me, I absolutely wanted to continue, but using my real name did give me pause. Of course, the defendant knows whom he illegally and immorally recorded, but putting my real name on the law enforcement and legal paperwork made me feel like I'd be that much open to retaliation. I can see why people feel using a real name is such a barrier to pressing charges. So those were some of her words. I know that she wanted to be here today, but I would ask for your favorable recommendation of
Thank you
this.
so much for your testimony, and I appreciate you bringing all the victims' information as well. Okay. Okay. Just
Yes,
want to clarify
and
that
to be
you're
clear,
testifying
I'm
on your
here
behalf.
testifying on my own behalf and on behalf of the Travis County District Attorney's Office.
Thank you so much. Members, you have any questions? No. Thank you so much for your time. Thank you for waiting. Is there anyone else who wishes to testify on, for, or against HB 3005? If not, the chair recognizes Representative Flores to close on her bill.
Members, this is a small bill that would have a big impact on victims of indecent assault and intimate visual recordings. I ask for your favorable consideration and your support. And if there's no questions, I close. And I believe this would be a good bill to send to local and consent if you would so consider.
Thank you, Representative Flores.
Thank you so
Members, any
much.
questions of Representative Flores? Okay, thank you so much. If there's no objection, the bill will be left pending. Is there objection? The chair hears none. HB 3005 is left pending. The chair lays out HB 5007 and recognizes Representative Plesa to explain her bill.
Thank you so much, Chairman Bojani, Representative Bowers, and Representative Cook for giving me the opportunity to lay out House Bill 5007 for you. House Bill 5007 is a good governance and judicial efficiency bill. Texans have the right to seek an expunction under a couple of circumstances, including when they have been acquitted of an alleged crime. Currently, 10% of all criminal trials end in acquittal. Acquitted Texans have to submit a petition for expunction, undergo an arduous and costly process to have their records clean. Texans have to incur court costs and fees and the cost of legal counsel to pursue an expunction. This is in addition to the court costs and attorney fees already incurred to defend against the underlying offense. Members, we have a presumption of innocence under our Constitution, and once someone has gone to great lengths to prove their innocence in court and have been acquitted, all of our government records should reflect that innocence. Texans may be acquitted, but continue to ensure hardships finding housing and employment due to their arrest records associated with crimes for which they have been acquitted and found not guilty. House Bill 5007 allows for efficiency within our judicial system and relieves the acquitted parties of the burden to pursue the exemption and instead requires the court presiding over the cases to enter an order of expunction within 30 days of the acquittal. This will conserve our judicial economy, relieve innocent Texans of incurring more costs and stress to maintain their good name, and will prevent additional hardships arising from a false allegation. Many counties hold expunction expos. In Collin County, we expunged over 100 records in 2022. Members, this bill is a common sense, workable solution for our state. While the members of this subcommittee and myself represent suburban districts, I have considered the effects and feasibilities of implementing this program in rural areas, and I believe that House Bill 5007 is a policy solution that can be implemented across our state without any fiscal impact. Members, I ask for your favorable consideration, and I reserve my right to close.
Thank you, Representative Plesa. Members, do we have any questions? Thank you so much. We'll proceed to testimony. Chair calls Maggie Luna.
She's not here.
No, okay, all right. We'll show the record that she's not testifying. Chair calls Sarah Mae Jennings. Thank you for being here. Just want to clarify the record, you're Sarah Mae Jennings testifying on behalf of yourself and Texas Fair Defense Project for HB 5007.
That's correct. Thank you. My name is Sarah Mae Jennings. I'm the interim co-executive director and policy director at the Texas Fair Defense Project. We're a nonprofit organization that fights the criminalization of poverty in Texas, and I'm here today to express very strong support for House Bill 5007, which will actually automate expunctions of criminal records after an individual is acquitted at trial. In a petition-based record clearing system like Texas's, only 6.5% of eligible records are successfully cleared. Criminal record clearing is complicated, costly, and time-consuming. Seeking criminal record clearing relief is difficult for an attorney and nearly impossible for a non-lawyer. No form of criminal record clearing in Texas is fully automated at this time. Most all criminal record clearing relief requires the accused to petition for that relief. And there's no right to counsel for criminal record clearing, leaving this relief inaccessible for indigent Texans. Just this past month, someone contacted our office asking for help obtaining an expunction following his acquittal at trial. I told the person that they should speak to their trial attorney about getting their expunction done quickly, knowing that the special provisions for expunctions following an acquittal under 55.01A1A, namely the waiver of the $250 to $350 filing fee, are only good for 30 days. The applicant told me he had asked his attorney, and the attorney was asking him for another $1,500 to handle that expunction following the acquittal. $1,500 that he could not afford. Typically, a single expunction or non-disclosure case takes one of our trained staff attorneys about 4 hours, but sometimes much more. Pro bono record clearing services across the state are limited, especially in rural areas. Pro bono record clearing services at TFDP, we help as many individuals as we can, but there will always be more Texans in need of this assistance than we and the other pro bono resources in the state are able to help. Expunctions are a tool to eradicate the barriers to employment, housing, public benefits, and more that criminal records create. I urge you to support this bill to ensure that Texans who have been found not guilty at trial can move on with their lives without a record following their acquittal. Thank you.
Thank you, Ms. Jennings.
Happy to answer any questions.
Members, any questions? Vice Chair Bowers.
Thank you, Chairman Bojani. So I'm just wondering, I thought I heard you say an additional $1,500, and so what normally is the cost for an expunction about?
So I think that's the going rate for private attorneys. As I said, I'm a nonprofit, so we don't charge our clients who are under 200% of federal poverty guidelines. In my experience as an attorney, the filing fees range between $250 to $350. So if you're trying to seek that relief without the assistance of counsel.
And then, as you said, that attorney in that case required an additional $1,500 on top of that. And then I guess, when you talk about the complications of the process, what can some of those twists and turns?
Sure. How much time do we have?
Just one example.
The law around expunctions and non-disclosures is incredibly complex. This piece of legislation is seeking to address a pretty simple avenue to expunction. It's if you're acquitted following trial, you're expunction eligible. So there's not much play there. Although I will say, my colleague brought up earlier today that in the occasion that there are multiple incidents within a single arrest, multiple different events that could give rise to potential complications even within the acquittal. But between the way the law is written and the way the law has been interpreted through the courts, it is quite messy.
Well, that does answer it. And I mean, I just, wanted to know what that typically might look like. But.
Yeah, so I'll just add that in the petition, the person's being asked to give all of their biographical information they're invited to provide under the statute. They're having to say what part of the law allows them to petition for the relief. So give the legal provision that says, this is why this piece is eligible. And they're having to list out every agency that might have the records that they're seeking to expunge or seal, because all of those agencies will have to then be notified of sealing or expunging these records if the order is granted. So those are the three big pieces of just assembling that petition that comes after deciding you're eligible and before even going to the court to petition and having a hearing and all that. So,
thank you. Yes. Thank you so much.
Yes, thank you.
Thank you, Ms. Jennings. Thank you for being here.
Thank you.
Is there anyone else who wishes to testify on, for, or against HB 5007? If not, the chair recognizes Representative Plesa to close on her bill.
Thank you, Chairman and members. 11 other states has implemented the automatic expunction change, including Florida, Georgia, Maine, and Montana. I hope I can count on your support and favorable consideration, and I hope you will share your support with the members of the full committee on criminal jurisprudence. I'm happy to answer any questions, and with that, I close.
Thank you, Representative Place. Members, any questions? Right, thank you very much.
Thank you.
If there's no objection, the bill will be left pending. Is there objection? The chair hears none. HB 5007 is left pending.
All right, Chair lays out House Bill 5159 and recognizes Chairman Bojani to explain the bill.
Thank you, Vice Chair Cook. Thank you, Vice Chair Bowers. When a jury has expressed multiple times that they are deadlocked, a judge may issue a charge known as the Allen charge. This charge explains to the jury that no other jury would hear anything different than they already have, and that they have a duty to conscientiously decide the case. The judge is not asking jurors to change their minds with an Allen charge, but rather reminds the jury that the alternative is to restart the entire trial with a new set of jurors. Oftentimes, this can be interpreted as a last resort, last effort to get the jury to reach a unanimous decision. After the court delivers an Allen charge to the jury, both the prosecution and the defense may present an additional argument. However, this is not clear in the current statute, leading to unequal application of this provision, meaning that some judges will allow for the additional argument while others will not. This bill simply codifies that both the prosecution and the defense have a right to present an argument to the jury after a subsequent charge has been issued. Members, we have a duty to ensure both parties have an equal opportunity to present their argument. I'm grateful to my colleagues who have signed on to this bill. Thank you, Chair Moody and Vice Chair Bowers. At this time, I'd be happy to answer any questions, and I would humbly request the opportunity to close.
Any questions, Ms. Bowers? All right, we'll move to testimony at this point. All right, the first witness we have is Alan Place. Alan, show you're testifying on behalf of the Texas Criminal Defense Lawyer Association and probably on behalf of yourself, and you're for the bill.
Yes, sir.
You may proceed.
Thank you, Chair Cook. Very quickly, this is, in our opinion, a simple clarification bill. While it's important, this circumstance is only going to apply in jury cases and only in a situation where there may be a further, is how the law looks at it, which is really defined as a second or a subsequent written charge to a jury. So the reason this bill is needed is current law is written in the singular in that it says the state and the defense have a right to present an oral argument to the jury on the court's charge. Okay. The bill clarifies that there is a right to an oral argument by the parties if there's a further, again, second or subsequent written charge is given to the jury. So it's a very rare situation, but it would just allow an argument to be made. Again, it does not change the pattern of the argument. State still open and closes. It just would give an opportunity to present an argument in that rare situation. That's all.
Any questions? Thank you for your testimony.
Thank you.
Is there anyone else that wants to testify on, for, or against House Bill 5159? Hearing none, will Chair recognizes Chairman Bojani to close on House Bill 5159.
Thank you, Vice Chair Cook and Vice Chair Bowers, for hearing House Bill 5159. We have an opportunity to ensure that our justice system is more fair for all. I would ask for your favorable consideration on this bill, and I close.
Thank you, Chairman Bojani. If there's no objection, the bill will be left pending. Hearing none, the chair will leave House Bill 5159 pending.
The chair lays out HB 3871 and recognizes Vice Chair Cook to explain his bill.
All right, thank you, Chairman Bojani. Appreciate the opportunity to lay out House Bill 3871. This bill was brought to us by our Tarrant County District Attorney's Office, and I'm honored to bring it before the committee. So, in 2022, we had 430 people that were arrested and being held in Kinney County, which filed habeas corpus applications in Travis County. During the first hearing on these habeas corpus applications, the Travis County District Court did not transfer the habeas corpus application to a Kinney County court, nor allow the Kinney County attorney to represent the state's interest. Ultimately, the Court of Appeals issued an opinion that the Travis County District Court could not exercise its jurisdiction outside of Travis County, stating, quote, "One of the cardinal principles of our system of government is to localize the administration of the law, to try causes in the county and before the court, having a primary jurisdiction thereof." House Bill 3871 updates outdated language in Chapter 11 of the Code of Criminal Procedure to be consistent with current case law and practice, which is to file habeas corpus applications in the county where the person has been charged or is being held. If the application is filed after an applicant has been accused of or charged with committing an offense, House Bill 3781 requires a habeas application to be filed, heard, and ruled on in a court in the county in which the felony or misdemeanor is pending. If the application is filed before an applicant has been accused of or charged with committing an offense, House Bill 3871 requires a habeas application to be filed in either the county in which the person is in custody or in the county where the offense is alleged to have occurred. I'm a firm supporter of local control and believe that our criminal justice system should be administered locally, just as the Court of Criminal Appeals has said. Mr. Chairman, available for questions from the committee, and respectfully would like the opportunity to close when appropriate. And I stand corrected. This one was not brought to me by the Tarrant County District Attorney's Office. It was actually in discussion with Senator Phil King. So that's, I just want to make that correction. But available for any questions.
Thank you, Vice Chair Cook. Members, any questions? No? Okay.
Thank you.
I think also, don't go too far. Is there anyone else who wishes to testify on, for, or against HB 3871? If not, the chair recognizes Vice Chair Cook to close on his bill.
Thank you, Chairman. If there are not any questions, I close.
Thank you, Vice Chair Cook. If there's no objection, the bill will be left pending. Is there objection? The chair hears none. HB 3871 is left pending. Chair lays out HB 2961 and recognizes Vice Chair Cook to explain his bill. The chair offers a committee substitute to HB 2961.
Thank you, Chairman Bojani. Appreciate the opportunity to lay out House Bill 2961. This is a bill that came to us through the Tarrant County District Attorney's Office and deals with, in a capital murder case in Texas, a person may be convicted under the law of parties for the criminal conduct of another. Specifically, the law of parties says, quote, "If in the attempt to carry out a conspiracy to commit one felony, another felony is committed by one of the conspirators, all conspirators are guilty of the felony actually committed, though having no intent to commit it. If the offense that was committed is in furtherance of the unlawful purpose and was one that should have been anticipated as a result of the carrying out of the conspiracy." However, Section 7.02 of the Penal Code does not include a definition of conspiracy for use by juries, making deliberations in capital murder law of parties cases incredibly difficult. After conferring with stakeholders, the committee substitute, did you lay out the committee substitute?
Yes, thank you.
After conferring with stakeholders, the committee substitute pivots from Chapter 36 of the Code of Criminal Procedure to Section 7.02 of the Penal Code. The committee substitute for House Bill 2961 defines conspiracy as, quote, an agreement between two or more persons to commit a felony in the Penal Code. Serving as a juror for a capital murder case is already emotionally taxing experience. It should not also be legally vague and confusing experience. More clarification from our courts on the definition of conspiracy is beneficial to our pursuit of justice. Mr. Chairman, I'd like an opportunity to close when appropriate and would be glad to answer any questions that may exist on House Bill 2961.
Thank you, Vice Chair Cook. Members, any questions? If not, we'll proceed to testimony.
Thank you.
The chair. The chair calls David Gonzalez. Thank you for being here. Just want to correct the record. David Gonzalez, your name is David Gonzalez, and you're testifying for yourself and Texas Criminal Lawyers Association and testifying against this bill.
Yes, sir.
Okay, thank you.
Thank you. The basis for our testimony, and we appreciate the work that we've done at the Tarrant County office in those conversations as well, is that in trial at the charge conference, the lawyers each submit the charge they want to the judge. And each side gets to say, this is what I want you to say a conspiracy is, or whether it applies in this case. And the court makes that decision case by case, fact by fact. And all the definitions that we have, there's a panel of law professors and lawyers and prosecutors and appellate judges that write up these model charges. And our understanding and our objection to the bill is not that the instructions are wrong. It's just that in a particular case, a judge didn't give an instruction to the Tarrant County DA's office in that trial. And there's lots of times where I would like an instruction, but I don't get it from the court. And so we would just ask that case by case, each locality, each trial, we keep everything the same for jury charges, and we don't put that in the statute and always say this is what's going to be instructed to jurors. And those are our concerns, and we think the process of the Supreme Court Rules Advisory Committee, the pattern jury charge, all the kind of organizations that work on these charges do that for that reason. And when we put things in the mandatory realm, it takes away that power for lawyers and judges to make those decisions.
Thank you very much for your testimony. Members, any questions? Thank you. Chair calls Lloyd Welchel. Get that right? Okay. Okay, the director will show that he's not testifying. Chair calls Lindy Barchard. Did I get that right?
Yes, Chair.
Okay. And just for the record, you're Lindy Barchard, testifying on behalf of Tarrant County Criminal District Attorney's Office, Phil Sorrells, for HB 2961.
Yes.
Thank you.
Good evening. I'm Lindy Borchardt. I'm Assistant Criminal District Attorney in Tarrant County, and on behalf of Phil Sorrells, the Criminal District Attorney, I fully support House Bill 2961. In this bill, it provides a straightforward definition of conspiracy in the law of parties. And this is important to have this definition in the actual 7.02B, which is the law of parties. And it's important to have this definition because when you go to argue jury charges and ask for jury charges, a pattern jury charge comes from the definitions that are in the penal code. And that's what we've seen. We have many, many definitions in the penal code, from definitions of a child to definitions of consent. There are numerous definitions in the penal code, and it's important that they are in the penal code for that specific provision. It's important in this, for this bill, because the definition for conspiracy, which is straightforward, is an agreement between two or more persons to commit a felony. And it's important in the law of parties because that's a law that is used in some of our most serious of offenses, capital murder cases. Those are very difficult cases for jurors to deliberate on. And the more information we can give them, such as this type of definition, it is better for our criminal justice system. It is best for jurors to have as much instruction through the jury charge as they can. And the fact that the definition will now be, because of House Bill 2961, actually in 7.02, which is law parties, that definition then will be incorporated into the pattern jury charge, which has already been referenced and testified to. With that, I appreciate Vice Chairman Cook on bringing this legislation. It's simple, it's straightforward, and it's needed. Any questions?
Thank you so much for your testimony. Any members, any questions?
Thank
you for your time. Is there anyone else who wishes to testify on, for, or against HB 2961? No one else wishes to testify on HB 2961. The chair recognizes Vice Chair Cook to close on his bill.
Chairman, thanks for the opportunity to lay this bill out, but glad to answer any questions. As I stated in the beginning of the layout, we did extensively work with stakeholders in an attempt to get an agreement. I felt like we had agreements on the definition, so if not, I will continue to work, but I do appreciate the opportunity to lay it out, and would be glad to answer any questions. Otherwise, I close.
Thank you, Vice Chair Cook. Members, any questions? No? Thank you so much. If there's no objection, the bill will be left pending. Is there objection? The chair hears none, and HB 2961 is left pending. The chair lays out HB 1940 and recognizes Vice Chair Cook to explain on his bill.
Thank you, Chairman Bojani. Appreciate the opportunity to lay out this House Bill 1940, which I believe is a very important and needed bill. This also was brought to me by our local district attorney in Tarrant County. This deals with the offering of bad acts that have been previously committed. Currently under Texas law, you're allowed to offer this type of evidence in crimes against sexual assault victims that are children, but not with regard to adult victims. And so that's the goal and the intent of this legislation. So as you probably know, in the first phase, generally speaking, in criminal cases, there's two phases. In a jury trial, first is the guiltiness phase, and then if the defendant is found guilty, then you move on to the punishment phase. In the first phase, jurors are presented with evidence and deliberate as to whether the defendant is guilty or not guilty. If the defendant is found guilty, the trial moves on, and in the second phase, jurors are presented with punishment evidence, including other crimes and bad acts committed previously. For sexual and assaultive crimes against children, prosecutors may offer evidence of other crimes and bad acts committed against the child victim, as well as sexual offenses against other children in the first phase of the trial. It is critical for jurors to know that the state of mind of the defendant, the relationship between the defendant and the child, and the character of the defendant. Evidence of a pattern of behavior is vital to jurors to determine guilt or innocence. House Bill 1940 expands the Code of Criminal Procedure to allow introduction of evidence of other crimes and bad acts committed previously by the defendant in the first phase of a trial related to sexual assault or aggravated sexual assault of an adult victim. House Bill 1940 provides important safeguards for the accused, including requiring the state to give advance notice of its intent to introduce evidence not later than the 30th day before trial. Additionally, before the evidence may be introduced, the judge must determine, outside the presence of the jury, of course, that the evidence will support a finding by the jury that the defendant committed the separate offense beyond a reasonable doubt. House Bill 1940 equips prosecutors with tools to establish a defendant's pattern of behavior and aims to protect adult victims of sexual assault and aggravated sexual assault, just as children are protected. I'd be glad to answer any questions that either of you may have. Otherwise, I'd like an opportunity to close when appropriate and be glad to answer any questions.
Thank you, Vice Chair Cook. Members, any questions? Yeah, Vice Chair Bowers.
Thank you, Chairman Bojani and Vice Chair Cook. I really appreciate this bill, but I did have a question. I think you answered it. You were saying that it is to introduce evidence of other crimes and bad acts that were committed previously, and then if you can share with us and state why that would be important again.
I think, well, like I said, at this time, it's currently, you're able to do that if the victim is a child, but not if the victim is an adult. And so that's one of the goals of HB 1940. And then I would say also as to when it is presented. So I think that's the goal of the bill.
So this changes that to be done when they're an adult as well?
Correct, yes, ma'am.
Okay.
That protects the adult victims as well.
Okay, thank you.
Thank you.
Thank you, Supervisor Chair Cook. Proceed to testimony.
Thank you.
The chair calls Stephen Brand. Thank you for being here. Just for the record, your name is Stephen Brand. You're testifying against HB 1940, and you're testifying on behalf of yourself and TCDLA.
That is absolutely correct. Thank you.
Thank you.
And thanks for the time. It is really difficult to explain this, why I'm against it in just a couple minutes, because there is so much literature that has been written, treatises have been written on the subject. This brings up the rules of evidence as they were codified in the 80s, basically, the federal rules of evidence, and then later the Texas rules of evidence basically mirror them. So what we're talking about here is character evidence and propensity evidence. So you can envision somebody who's being tried for burglary of a habitation, so burglarizing somebody's house. And with character evidence, what you're not allowed to do is say, well, you know what, 5 years ago he burglarized somebody else's house, so he has the propensity to burglarize houses, so we're going to put that in the guilt-innocence stage of a trial to show that, you know what, more than likely than not, even though the evidence might be a little flimsy here, we're going to bring that in. There's very specific rules of evidence to say when that should come in and when that shouldn't come in. The 38 section of the Texas Code of Criminal Procedure basically loosens that and says, basically, you know, if you've done these things in the past, just bring it in. And the problem here is when you're bringing that with regard to sexual assault victims, quote unquote, who are adults, you're now broadening that spectrum beyond just child victims. You're now continuing to eat away at this presumption of innocence. Because after all, and I'm sure you're bombarded with this, you hear this all the time, this group wants this group wants this protection. And I understand it, from the pseudonyms to everything. But the paramount thing, the number one thing when we talk about jury charges that the judge is going to say is that the presumption of innocence alone is enough to acquit somebody. That is the cornerstone of our criminal justice system, is the presumption of innocence. Anything that would begin to chip away at that on behalf of quote-unquote victims who aren't victims, really unless and until somebody is convicted, is really the wrong way to go. And what we're missing is fundamental fairness, because you have Rule of Evidence 412, which is a rape shield statute, which prevents the defense from bringing in certain evidence it might think is relevant against the quote-unquote victim in a sexual assault case. So you have the shield now being able to be used and has been able to be used by the alleged victim in the case, and now you're making it easier to bring in evidence against the accused in the case. And that's why this is fundamentally wrong. If you want to reshape the bill, so you're just letting everything in. You're going to say, okay, for an alleged victim, your substance abuse history comes in. All your therapy records come in. To level the playing field, I might think differently about it. But to just take one side of that equation and say, you know what, we're bringing this all in against this person no matter what, that's the wrong thing to do. And it's not the cornerstone of what we believe in. It's not fundamentally fair.
Thank you, Mr. Brand, for your testimony. Members, any questions? Thank you for your time. Chair calls David Gonzalez. Thank you for being here. For the record, your name is David Gonzalez, and you're testifying for yourself and Texas Criminal Defense Lawyers Association against HB 1940.
That is correct, sir.
Okay, thank you.
And to pick up on your question, Representative Bowers, related to the law and what can be done. So under the current law, it's hard to classify certain grooming behaviors as bad acts. And so we give exceptions to kids. So when a grown-up has a inappropriate relationship of giving gifts or taking that kid and doing special things, the rules of evidence for 404B talk about crimes, wrongs, and other acts. And so because some of those things don't fit neatly, I think, in that section, we created this exception for what adults who are predatory can do to kids. So any prosecutor at any time doesn't need the exception. You can just say under 404B, if you've got a serial killer or someone that has the same pattern, as long as I can show motive, opportunity, intent, preparation, plan, knowledge, identity, absent a mistake, lack of accident. If I can prove any of those actions, then I can bring in character evidence. That's the current law that both of us operate under. To echo on what the last witness had said, the concern is that when one side says you can't cross-examine anybody about their sexual past, but on the other person you can, it just becomes unfair. So if both sides have the same rules, and there's no rape shield law, and the bill also takes away Rule 412 and says either side can talk about either side's past, then I think we agree. That becomes fair. But when one side says, no, this is sacrosanct, you can't do this, but yet we get to put the defendant's past sexual history on trial, our concern is it's no longer the same fair system.
Thank you, Mr. Gonzalez. Members, any questions? Thank you very much for your testimony. Chair calls Jeff Swain. Thank you for being here. For the record, your name is Jeff Swain. You're testifying on behalf of Parker County District Attorney's Office, and you're testifying for HB 1940. Is that correct?
That's correct. Thank you very much, Mr. Chairman, members of the committee, for the opportunity to talk with y'all today. I am the district attorney in Parker County. I'm testifying in support of House Bill 1940. The rest of Article 3837 was enacted in 2015, and I just wanted to be able to testify and tell y'all that since that was put into place, that has absolutely been transformative in the way that we can prosecute multiple victim child sexual abuse cases and hold those offenders accountable in the criminal justice system. Prior to Article 3837 being put in place, each victim was basically on an island alone, carrying the bulk of the weight of the burden of proof against a practiced sex offender, a person who's had prior sexual assault of a child victims. After this has been put in place, that weight is shared amongst the victims. Their testimony supports the testimony of the other victims, and their collective weight of their testimony has been incredibly, incredibly powerful. I think that this bill can allow that same transformation to occur for sex offenders who choose to repeatedly sexually assault adult victims, or frankly, it would allow for situations where some of the victims are children and some of the victims are adults. 17 is the age of consent for sexual purposes. So you could have what we would commonly all consider a child, a person who's still in high school, but is an adult for sexual purposes and the ability to consent. So this bill would allow for that for an offender who has repeatedly sexually assaulted adults or a mixture of adults and children. I could give you examples of cases that I've handled, but it is late and I'm going to spare you from that. But I do want to say the reason why 3837 is a law in our state for children, and I think that the same rationale rings true for adults. The very nature of sexual assault is just different than theft or burglary or DWI. There is such a moral barrier, a moral inhibition to engaging in this particular type of conduct. We're not just talking bad acts. We're not talking things that they did that were bad. We're talking sexual assault and aggravated sexual assault, things like that. It's just different. And so I would urge your support for this bill because it would allow the benefit that we've had for children to be expanded over to the adult realm, and I would be happy to answer any questions that y'all may have.
Thank you for your testimony. Members, any questions? Okay, all right.
Thank you all very much.
Thank you for your time. Chair calls Tracy Matheson. Thank you for being here. For the record, your name is Tracy Matheson. You're testifying on behalf of yourself for HB 1940. Is that correct?
That is correct.
Thank you for your time.
Yes. Thank you, Chairman Bojani. Thank you, Vice Chairman Cook. And thank you, Representative Bowers. My name is Tracy, and I am representing myself and am providing testimony in enthusiastic favor of House Bill 1940. In September 2019, House Bill 3106 became law in the state of Texas and is known as Molly Jane's Law. Molly Jane is my daughter, and she was raped and murdered on April 10th, 2017 by a serial rapist who had been investigated for raping and strangling women by multiple law enforcement agencies in the state of Texas. They knew his name, they knew where he lived, they had collected his DNA multiple times. They had interviewed him multiple times. They knew there was a CODIS hit linking him to 2 different cases. They even arrested him once. Yet not one of the law enforcement agencies or district attorneys did anything to stop him. Had our case gone to trial, we had 12 women prepared to testify. So we passed a law to help law enforcement connect the dots between cases. And we have proof that Molly Jane's Law works because serial offenders have been identified and held accountable and are in prison. Since the preventable rape and murder of Molly Jane, it has become my life's mission to use our story to illustrate why we must do better. House Bill 1940 would be an excellent step in the right direction as we strive to do better on behalf of those who experience sexual violence. As it is right now, cases of sexual assault are some of the hardest cases to investigate and prosecute. There are so many reasons for this fact. As a result, serial rapists are left to continue to rape without fear of consequence. House Bill 1940 would equip prosecutors with the ability to include previous bad acts committed by an offender in an adult sex assault case and demonstrate how the pattern of offending is a part of their character. This would mean serial offenders could be stopped before they rape again or before their pattern escalates as it did with the individual who raped and killed my daughter and another woman 5 days after Molly. Those who are serial rapists are some of the most dangerous individuals. We recognize this with cases involving children and previous bad acts are allowable. Cases involving sexual assault against an adult are every bit as dangerous and should receive the same consideration when a serial rapist is prosecuted. Had House Bill 1940 been law before Molly was killed, I have to wonder if she might be alive today. Might law enforcement have been more willing to take this offender seriously if they knew his pattern of behavior and previously reported rapes and strangulations could be used by the prosecution? Might the district attorney who was presented a case against the person who raped and killed my daughter have been more willing to take it seriously if the previous bad acts could have been considered and used in the case? We will never know the answer to that question. I can tell you that passing House Bill 1940 will save lives. I implore you to vote it out of this committee so that it can do just that. Thank you
Ms.
very
Matheson,
much.
for your testimony, and I'm so sorry for what happened to your daughter. Members, any questions?
Thank you, Chairman Bojani, and Ms. Matheson, thank you for your testimony again. As Chairman Bojani said, I'm so sorry for your loss, but I thank you for using, your life to be an advocate for your daughter and for others, and so that this won't continue to happen.
Thank you very much.
Thank you.
I just want to make one quick thank you, Vice Chair Bowers. I just want to make quick clarification. I don't want to have a point of order on this. So you mentioned another bill or another law, but you're testifying on 1940.
Correct.
Right. Okay.
Yes.
Perfect. Thank you so much.
Uh-huh.
Thank you for your testimony.
Thank you.
Chair calls Jennifer Tharp. Did I say that properly?
You did.
Okay.
Thank you.
Thank you. I just want to quickly, for the record, your name is Jennifer Tharp. You're testifying on behalf of yourself and on behalf of Comal County Criminal District Attorney's Office for HB 1940. Is that correct?
That is correct. Thank you so much.
Your time.
Good evening, Chair, Vice Chair. I'm testifying in support of HB 1940. I have been a Texas prosecutor for the last 19 years, the elected for 13 years. And I just would like to dovetail on not only what Ms. Matheson said, but also several of the witnesses before when they talk about the sensitive and very difficult type of case that is of sexual assault, especially when it pertains to an adult victim. It's hard for children. I would submit to you, sometimes it's even harder for grown women to get on the stand and understand that when they're getting on the stand to talk about some of the most intimate, embarrassing, difficult, traumatic abuse they've endured, that's after they've undergone a rape kit, where they have had every inch of their body swabbed, photographed, poked, prodded, you name it. And that's even before they testify. I anticipated some of the opposition tonight, and I will tell you it's pretty familiar to me because I worked really hard back in 2019 to get enacted 38371. And that deals with domestic violence cases and when other bad acts should come into play for domestic violence cases. Back then, it was argued that the rules of evidence already allow this. It shifts the burden of proof from the state to the defense. It could thwart justice. It could lead to wrongful convictions. What I would submit to you is Texas law, this body, the legislature, has recognized certain type of criminal offenses where evidentiary rules should come into play. For theft, we have 3803C. For prosecution of murder, we have 3836. Child sexual abuse, 3837. Victims of stalking, 3846. And tampering with a witness, 3848. I will tell you the important thing to realize is there's an important gatekeeping function by the judge. So before a jury even hears about these other bad acts, there is a hearing outside the presence of the jury where the judge listens to the evidence. Not only listens to the evidence, but makes sure that there's sufficient evidence for a jury to believe that other bad act beyond a reasonable doubt. Only then may a judge decide, if appropriate, to allow the jury to hear it. Again, there's another checks and balance because a defense could argue 403, which is that the evidence is more prejudicial than probative. Finally, only if a jury hears this, the jury is instructed that before you can consider that other bad act, you have to believe that the state has proved it beyond a reasonable doubt. And only then may you consider it. So I would submit to you there are plenty of safeguards. It's a late hour, so I'll wrap my testimony short. Happy to answer any questions, but I will highlight this. April is Sexual Assault Awareness Month. And tonight, this committee, this subcommittee, has an opportunity to go beyond ribbons, to go beyond resolutions, and respond to this month with action, which is favorable support of HB 1940. So happy to answer any questions, and I appreciate your time.
Thank you, Ms. Tarr, for your testimony. I just want to quickly clarify. I know you mentioned 3871 from last session. I just want to make sure
No, I'll clarify. Not actually last session, it was from 2019.
Okay, but you're testifying on HB 1940.
1940 in support, yes.
Thank you.
Thank you.
Vice Chair Bowers.
Yes, thank you, Chairman Bojani. And is it DA Thar?
Yes, ma'am.
Okay, thank you, and thank you for your service. So I guess I agree with you totally, and I understand and can only imagine, but do understand the severity of sexual assault, and can't imagine having to go through, the rape kit and the testing, and then have to repeat all of that. But I guess I wanted to know how you feel about what was said before about it chipping away at the defendant's, I guess, innocence.
I appreciate you asking that question because I was trying to get all my talking points in my quick minutes. So as to whether or not it chips away the defendant's presumption of innocence, obviously every criminal case we start with, the defendant is presumed innocent. The state still bears the burden to prove each and every element beyond a reasonable doubt. Before the state can even go into any other type of extraneous, or we often call it other bad act, First off, the state is required to give notice. We give notice 30 days in advance of trial. We let the defense know, hey, this is the other bad act that we are going to ask the judge in a hearing outside the presence of the jury before we can go into it. Only after the judge considers that particular evidence will the judge then say, yes, you may go into it, or no, you may not. What was interesting in some of the defense's arguments earlier is he talked about the Rape Shield Act, which absolutely does exist. But what also wasn't talked about is 412, we call it a 412 hearing. We have a hearing outside the presence of the jury where there are questions asked of the victim with regards to prior sex acts of the victim. That judge, after a hearing, can allow some of the defense questions to go exactly into that moment. And so it's two sides to the story, and the importance is that it's not a situation just because the state has the evidence, they get to go into it. You still have that gatekeeping function with the judge, making sure that it's the right evidence. And as a prosecutor, one thing that we are very cautious of is before I go in and try to urge and submit any other extraneous evidence into a case, I gotta know that I'm standing on solid ground legally, because I may get that guilty, then lose it on appeal. And that does the victim no justice. Does that answer your question?
It does indeed. Thank you.
Thank you so much for your testimony. Appreciate it.
You're welcome.
The chair calls Leighton D'Antoni. Did I get that right?
Yes.
Okay, thank you.
Chairman, members of the committee, thank you for your time and patience. My name is Leighton D'Antoni. I'm an assistant district attorney in Dallas County. For the past 8 years, I've been...
Sorry, just want to clarify for the record, you're testifying for HB 1940?
That is correct.
And on behalf of Dallas County Criminal District Attorney's Office?
That is correct.
Thank you.
For the past 8 years, I've been the chief of the Cold Case Division, which includes the Department of Justice's Sexual Assault Kit Initiative, or SAKI, program. Since 2015, through this SAKI program, which is the testing of untested rape kits in Dallas County, we have identified over 300 offenders. 85 of those offenders are serial rapists or serial killers. And what I think it's really important and has been spoken about on this bill is that this bill mission and the mission of my team in Dallas is to identify and prosecute serial rapists and serial killers. We are not talking about the single victim, he said, she said case. We are talking about the worst predators that we see out in society, the biggest threat to our community. I'm sure you know that, sexual related offenses, whether they be sexual assaults or murders involving a sexual assault component, typically in studies and have shown that these aren't, one-offs. These are people who are going to continue to commit this crime unless they are stopped. And this is absolutely one of the most important tools we can have to not only identify these serial offenders, but to stop them. And these defendants are still going to have all the safeguards and protections of the United States Constitution. And I know it was characterized earlier that, we're trying to bring in character evidence, but this is not character evidence. These are bad acts that are previously sexual assault related that show a tendency and a pattern. We're not, again, talking about character. These are acts. Serial rapists are smart. They target the most vulnerable members of our community. Prostitutes, drug addicts, people with mental health issues, people that they don't think anyone's going to believe. And so that is why this is such an important bill, is that we have a duty to protect everybody. We already do it with children, but we should have equal protection of all sexual assault victims, not just children, but adults as well. And so this law will allow the state of Texas to identify and prosecute serial rapists, serial killers who for decades have been able to run roughshod over our communities, and it's time to stop. Thank you.
Thank you for your testimony. We appreciate it. Thank you. Is there anybody? Okay. Chair calls Lindy Borchardt. Thank you again for being here. For the record, you're Lindy Borchardt, testifying on behalf of Tarrant County Criminal District Attorney for HB 1940. Is that correct?
Yes.
Thank you.
Good evening. Chairman Bojani, members of the committee. I'm Lindy Borchardt. I'm Assistant Criminal District Attorney in Tarrant County. And on behalf of Phil Sorrells, the Criminal District Attorney, I fully support HB 1940. Currently, Article under the Code of Criminal Procedure 3837 applies to child sexual predators. And legislators believe that it is important for jurors to hear evidence of a common pattern of predatory behavior of the defendant. Evidence on how the defendant targets their child victim that they're going to rape. It's that type of pattern and evidence of that type, a pattern of predatory behavior that is critical for the jury to be able to understand the crime that he has alleged to have been committed. So just as we have child sexual predators, there are also adult sexual predators, serial rapists. And this bill, HB 1940, narrowly expands 3837 to adult sexual predators. Because just as you saw the importance of jurors hearing that type of evidence in child sexual assault cases, that type of evidence is also important in adult sexual predators, against adult sexual predators for adult sexual assault cases. Evidence of the common pattern of predatory behavior of that defendant. There's been a lot of testimony on this bill as far as the safeguards that are already in place. And so I won't go over that again. But before this type of evidence can be introduced, we have to give notice 30 days before trial, and there's actual a pre-trial hearing because the judge must ensure that I can prove that the evidence I'm wanting to offer beyond a reasonable doubt. And so there's safeguards that are in place, and those are important safeguards that need to be in place. But it is critical that jurors are able to hear the defendant's patterns, his patterns of predatory behavior, because only then can jurors get a true sense of the danger that this serial rapist poses, not only to the victim of the alleged offense, but also victims that he will continue to prey upon. Thank you. If you have any questions?
No, I'm okay. Thank you for your testimony.
And
Appreciate
thank you,
it.
Vice Chair Cook, for bringing this important legislation. Thank you.
Is there anyone else who wishes to testify on, for, or against HB 1940? If not, Chair recognizes Vice Chair Cook to close on the bill.
Thank you, Mr. Chairman. I appreciate the opportunity to lay out House Bill 1940. I think we heard a lot of really compelling testimony this evening, and I hope that you find the arguments made by these criminal defense attorneys as repugnant as I did. To imply that it's okay for a rapist, to be, take a moment here, because I don't want to overstate this. I don't want to get into a jury argument here, closing arguments or anything like that, but I just want to state that the arguments that they're making is that a adult should not be protected to the same extent as a child. And if so, if then basically their argument tonight is if we're going to allow this, then let's put the victim on trial as well. That's what they're implying. And so I find it very sickening that that's the type of argument that they would bring in here tonight. And I would just encourage you to look at the bill itself. The bill is a short, very short, 2.5-page bill. It's very specific. There's no repeal language. It's simply amending the language, and it's very clear at the top of page 2 what this bill is intending to do. It says that prosecution number 3 is if committed against a person of any age, and so it's making it clear that it's not just children that are being protected, but a person of any age, and then it lists the offenses there. But otherwise, the bill is simply expanding the verbiage from child to any person, meaning adults are included as well. So anyway, I just appreciate the opportunity to lay out this bill, and I would appreciate the favorable consideration of the committee and would be glad to answer any questions if you have any.
Thank you, Vice Chair Cook. Really appreciate it.
All right, I close. Thank you.
If there's no objection, the bill will be left pending. Is there objection? Hearing none. HB 1940 is left pending. The chair lays out HB 303 and recognizes Representative Bernal to explain their bill.
Thank you, Chairman. I appreciate it very much. I've been where you guys are, where there's a couple of you, and I also know what it's like to be a junior member and wait. I will go very, very quickly to get this done. HB 303 seeks to amend the code to no longer allow a justice or municipal court to order an individual confined to jail for a failure to appear or pay all or part of their fine only in cases in which the offense is punishable by a fine only. What that means is that you can have some infraction. The only thing in law that can happen to you is a fine. But for whatever reason you don't pay that fine, judges are allowed to then, because you haven't paid, put you in jail. And I think that there's something wrong with that. I think if the crime or the issue itself is only punishable by a fine, then we keep it at a fine and we figure it out, but we don't we don't take the failure to pay a fine for something that you can't be thrown in jail for, but then be able to throw you in jail for not paying the fine. Texas has a very elaborate system that they use to keep track of people who have fines and not pay fines, and use that system called Omnibase to actually pile on the fines, which then results in more Texans being placed in jail unnecessarily. So all this bill does is sort of reinforce this idea that if you owe money and the infraction is something that is only punishable by a fine, that there's nothing that can happen to you that would result in the indignity of being arrested and put in jail for something that in law is only punishable by a fine. Happy to take any questions from the committee. And I reserve the right to close. And I'm going as fast as I can, my guy.
Thank you, Representative Bernal. Don't go too far. Is there anyone else who wishes to testify on, for, or against HB 4037? If not, Chair sorry. 303. Oh, sorry. Oh, I'm so sorry. Moving fast. Hold on, sorry. Okay. Is there anyone who wishes to testify on, for, or against HB 303? If not, Chair recognizes Representative Bernal to close on his bill.
I close.
Thank you so much, Chairman. We appreciate it. All right. Is there no, if there's no objection, the bill will be left pending. Is there objection? The Chair hears none. HB 303 is left pending. The Chair lays out HB 4037 and recognizes Representative Hayes to explain his bill. Thank you so much, Representative Hayes, for waiting. I know you've been waiting for a long time.
Not a problem, Mr. Chairman. Thank you for the opportunity to lay out House Bill 4037. When a criminal defendant deems, or when a criminal court deems a defendant incompetent to stand trial, the trial court will order the defendant be committed to a state hospital or qualifying mental health facility for competency restoration services. This is a problem sometimes because currently the Health and Human Services Commission is experiencing a severe staffing shortage, causing 740 of their 2,241 funded beds to become offline and unavailable for occupation by patients. The results of having only 67% of their beds online is that as of January 2023, the wait list for available forensics beds is over 2,500 persons, with the average wait time being 241 days to get a defendant into a bed. Unfortunately, due to the court backlogs and delays, some defendants fall back into incompetent status while in jail waiting for their pretrial hearing. So what happens is we send them to an institution, we get them well, they are now competent, but it takes so long to get them back into the jail system, and then they're in the jail system waiting that they fall back into no longer being able to stand trial. Well, the goal is to get them in pretrial hearing as quickly as we can. And so this bill addresses this concern by establishing a reasonable time frame for defendants who have completed the competency restoration and requires them to have a pretrial hearing within 30 days of that restoration. Thank you, Mr. Chairman and members, and I believe we have witnesses, so I yield.
Thank you, Representative Hayes. Are there any questions for Representative Hayes? Okay, thank you. We'll move to testimony. Chair calls Greg Hensch. Did I get that right? Yes. Okay, thank you. And for the record, your name is Greg Hensch, and you're testifying on behalf of National Alliance on Mental Illness. And and you're testifying for HB 4037, is that correct?
That is correct. Thank you.
Very much.
Appreciate it, Chairman. This bill would expedite justice for one of our state's most vulnerable populations, Texans who have been restored to competency to stand trial and are now being held in county jail awaiting their day in court. The bill ensures an appropriate time frame from the moment an individual has their competency restored to the day of their pretrial hearing. When a defendant is deemed incompetent to stand trial, a judge will order them to a competency restoration program. These services are necessary to ensure due process. However, there are times in which after a person who has been restored returns to jail, their mental competence deteriorates again due to the length of time they wait, the setting that they're being held in, and the limited availability of services. And back to the state hospital they go. Not bringing these individuals to court in a timely fashion places further pressure on an already strained state hospital system. Having to return people back to the state hospital after their competency has been restored results in the inefficient use of limited resources in the state mental health system. We should be speeding up the movement of the forensic wait list, not slowing it down. Having to send people back to the state hospital also exacerbates mental health challenges, frustrates families, and re-traumatizes patients. It also strains county jails, who are burdened by substantial costs while people wait for their pretrial hearings. Since 2017, Texas has had a statute that reads, the trial of a criminal action against a defendant who has been determined to be restored to competency shall be given preference over other matters before the court. With HB 4037, you have the opportunity to strengthen this statute by providing concrete language on how quickly a pretrial hearing date should be held after competency is restored. We can develop a more efficient, humane mental health system by protecting the progress highly vulnerable individuals have made in their restoration. This means a pretrial hearing within 30 days. Thank you for the opportunity to testify in support of the bill.
Thank you for your testimony. Member, any questions? Okay, thank you, sir, for your time. Chair calls Brian Hawthorne. Thank you for being here, sir. For the record, your name is Brian Hawthorne, and you're testifying on behalf of Sheriff's Association of Texas and yourself, and you're testifying for HB 4037. Is that correct?
Yes, sir.
Thank you very much.
I'm Brian Hawthorne. I'm the Sheriff of Chambers County, just east of Harris County, and I'm here on behalf of 253 other sheriffs, and 135 of them have county jails that they operate. And this bill is spot on. And the testimony that you just received from is truly exactly what happens. They come to our jail, they're here for hundreds of days. They finally go to the state hospital. They come back to the jail and they sit and they sit and they sit and they go right back to where they were, and they need to go back to the state hospital again. So the bill is spot on. Whose fault it is, I'll let everybody else figure that out. Some people say it's the judges, some say it's the prosecutors, some say it's the defense. I don't know. I will say this. Some judges have a tendency to move it quicker and faster. So therefore, I don't know where it falls, but what I will tell you is this bill is a very good bill, and the Sheriff's Association of Texas supports it.
Thank you, Mr. Hawthorne. Members, do we have any questions? Thank you for your testimony. Chair calls Brandon Wood. For the record, sir, your name is Brandon Wood, and you're testifying on behalf of commissions on jail standards, and you're testifying on the bill. Is that correct?
That is correct, Mr. Chairman. Good evening, Mr. Chairman, members. Brandon Wood, Executive Director, Texas Commission on Jail Standards, serving as a resource witness on the bill. I'm not going to repeat the testimony that you have already received from Mr. Hanch or Sheriff Hawthorne. They both hit upon the pertinent points of the bill. Again, anything that can be done to expedite the process is of benefit to the county jails. These individuals that serve time in the county jails with mental health issues continue to be listed as one of the top 3 issues and challenges that our county jails face. So with that, I will be willing to answer any questions that you may have.
Thank you for your testimony. Members, any questions? Okay. Thank you for your time.
Thank you, sir.
Is there anyone else who wishes to testify on, for, or against HB 4037? So, okay. All right. You'll have to register, I think. Okay. before you start, I just want to make sure the record is clear. Your name is Morgan Saucer, and you're testifying on behalf of yourself, and you're testifying for HB 4037.
Yes, that's correct.
Thank you.
Good afternoon, good evening, Chairman and committee members. My name is Morgan, and I'm here representing myself to testify in support of HB 4037. In Texas, if mental competency proceedings are initiated, criminal proceedings are suspended in a limbo and cannot be resumed until the competency of the defendant has been restored. This process can take years, especially as Texas continues to see an alarming growth in the list of defendants currently residing in county jails waiting to be transferred to state hospitals for competency restoration services. It is my understanding that preliminary hearings in criminal cases are often as important as the trials themselves and provide those accused of crime an opportunity to settle cases before going to trial. Sometimes there is a lack of foundation that requires a case to move forward. Whatever the case may be, I do believe preliminary hearings are essential for all parties involved. Currently, Texas does not have a required time frame for that these proceedings must occur. Setting a mandatory time frame to conduct a preliminary trial hearing merits of a case, especially in those regarding a previously incompetent defendant. It benefits all parties involved, the state, defendant, victims, family members, and even taxpayers. This bill aims to address concerns regarding individuals who undergo competency restoration services in Texas and return to county jails only to fall back into an incompetent status while waiting for their case to proceed. This cycle gives unease to all parties involved and that their case will be stuck in legal limbo or purgatory for years. Families sit by and watch their loved ones go through mental anguish while waiting for justice, and this is something I wish no one in this room should ever have to endure, as I experience this anxiety daily. It's essential that we ensure the justice. It is essential that we ensure that the judicial process does not allow anyone to fall through the cracks by aiding this crucial deadline to conduct a pretrial hearing for these defendants. Thank you. I yield my time.
Thank you so much. I'm so sorry for what happened to you. Is there anyone else who wishes to testify on, for, or against HB 4037? If not, the chair recognizes Representative Hayes to close on his bill.
Thank you, committee members. I close.
Thank you. Thank you, Representative Hayes. Is there any questions? Okay. All right. If there's no objection, if there's no objection, the bill will be left pending. Is there objection? The chair hears none. HB 4037 is left pending. The chair lays out HB 4671 and recognizes Representative Hayes to explain his bill.
Thank you, Chairman Bahani, committee members. There is a committee substitute that you have before you.
No, we didn't get it.
You have not received that?
But you can talk about it if you.
Okay, thank you.
Yes.
The purpose of this bill is that district clerks or the jury clerk for a county whose duties include preparing and mailing summons. This is true for petit juries, that's just a regular trial court jury, as well as grand juries. However, it is currently unclear who are qualified officials to actually summon a grand jury. What is often happening in counties is the district clerk handles the administrative duties of pulling a list of potential jurors and preparing the summons, but in order to comply with the current requirements of Article 19A of the Code of Criminal Procedure, the summons are dropped off in the mail then by the sheriff. This bill updates the Code of Criminal Procedure to include the district clerk in preparing and summoning grand juries, as well as the sheriff. In most counties, the district clerk prepares the grand jury summons, so this places the current practice into the statute. This bill also addresses the disqualification of misdemeanor theft or felony conviction in current law, making it permanent. Currently, there is no language to allow for permanent disqualification of the persons will be disqualified from one jury, then placed back in the will to be pulled again when there's no way they can serve. This change will permanently remove them from the jury will. The Clerks Association worked with the Prosecutors Association in preparing this particular section. The committee substitute merely strikes a subsection of the bill that required a list of disqualified persons to be provided not only to the Secretary of State, but to the DA. So this was a concern brought to my attention by my own Denton County clerk. And I've spoken to the Clerks Association of the DAs, and they are neutral on the inclusion or removal of this particular requirement. So thank you, Chairman and members, and I believe we have witnesses, so I yield for testimony and reserve the right to close.
Thank you.
And I have a copy of the committee substitute, if I may approach.
Sure. Thank you.
And all it did is delete like the last couple of paragraphs.
Okay.
Thank
you. Members, any questions of Representative? Okay, all right. Thank you, Representative Hayes. We'll begin testimony. Chair calls Lisa David. Thank you for being here today. For the record, your name is Lisa David, and you're testifying on behalf of County and District Clerk Association for HB 4671. Is that correct?
Yes, sir.
Thank you.
As you said, I'm testifying in favor of House Bill 4671. Representative Hayes set out what the Clerks Association is requesting, and it clarifies certain procedures regarding the summonsing of grand jurors, and it sets out a detailed process of the jurors when they're disqualified. As the jury manager, I'm the district clerk in Williamson County, and, we do the whole process, and it stops at when the mailing comes. And so when the mailing of the summons, at that process, it goes to the sheriff. And so the Clerks Association is, again, asking that we just take care of the whole process, and this bill would allow the change that would give the authority to the district clerk to also mail those summons. Second, currently, persons convicted of a felony or misdemeanor theft, as stated, are disqualified from serving on the grand jury. And he's only disqualified from that panel that he or she is called on. And so they go back into the wheel, and, if they're lucky or unlucky enough, they'll be called back years or so later. And we're just asking that this bill clarify that we can notify, there would be a process set out for the district clerks and the county clerks or the jury manager to report to the Secretary of State to take those names out. It doesn't have anything to do with their voting rights. It's just jury duty. And basically that covers what we're asking. We think it's, just a cleanup bill, and I would just ask that you support this bill, and I thank you for your time.
Thank you. Thank you for your testimony. Members, any questions? No. Thank you. Is there anyone else who wishes to testify on, for, or against HB 4671? If not, the chair recognizes Representative Hayes to close on his bill.
Thank you, members. I'll close. Request your verbal adoption of this particular bill.
Thank you. Thank you, Representative Hayes. Any questions, members? No. Thank you. If there's no objection, the bill will be left pending. Is there objection? The chair hears none. HB 4671 is left pending. Members, that concludes today's agenda. Is there any further business for the committee to address? If not, the chair moves to adjourn. Is there objection? Hearing none, the committee stands adjourned, subject to the call of the chair. Thank you. Good night.